Hi everyone, welcome back to my channel. Today we are doing the cold call preparation. The case we're going to discuss today is River Park Inc. versus City of Highland Park. About this case, the case name is River Park Inc. versus City of Highland Park. Citation 703 NE2D AA3. Court, Illinois Supreme Court. And Justice, the judge is McMorrow. The date is 1998. Plaintiff is the River Park Inc. and defendant is the City of Highland Park. Procedural posture. How did we get here? On February 23, 1993, River Park filed lawsuit in Federal District Court against Highland Park. The claim is about the violation of 42 U.S.C. Section 1983. It is about the constitutional claim. And on July 22, 1993, the district court dismissed with prejudice. Of course, the plaintiff appealed to the appellate court, and the 7th Circuit affirmed the dismissal. So after a while, after 1 year, on November 21st, 1994, River Park filed another complaint, a 6-count complaint, in Illinois State Court. Now it's the State Court, before it was the District Court, against the same defendant. The defendant is the same, but the claims are different. So the claims include tortious interference with business expectation, breach of contract, abuse of governmental power. And these 3 claims remained. And the defendant's motion, Highland Park moved to dismiss under res judicata, claim preclusion, arguing that all claims arose from the same transaction litigated in the federal court. The trial court granted the motion, dismissed with prejudice, and the plaintiff appealed to the appellate court. Appellate court reversed the trial court's decision and finding claim preclusion did not apply. And the defendant appealed to the Supreme Court, and Illinois Supreme Court reversed the appellate court's decision and reinstated dismissal. So that's about the background of this case. How did we get here? Right now we are in the Illinois Supreme Court. The facts are about this case are very straightforward, very easy. River Park sought city approval to develop a country club property, but they alleged the city intentionally delayed approval of the plan in order to waiting for the foreclosure and then to buy by themselves. And after losing in federal court, River Park attempted to pursue similar claims in state court under different legal theories, tort and contract instead of constitutional. The issue we are going to discuss today is whether River Park's state law claims constituted the same cause of action as its prior federal Section 1983 claim, thus barred by the claim preclusion. The rule we're applying in this case will be the first one, res judicata, claim preclusion. There are 3 elements we're evaluating whether the 2 cases are from the same cause of action. The first one will be the final judgment of the merits, whether the determination, the judgment is the final. And then the second one, identity of parties or previous, whether the defendant and plaintiff are the same people, same group of people. And the third one will be the identity of cause of action, whether the 2 suits comes from the same cause of action. The previous 2 are very easy to identify, and then the most disputed section will be the element 3 because it is not very clear-cut. There are 2 tests will be used for whether they are from the same cause of action. The first one is we call same evidence test. It is the old rule, and this test evaluates 2 suits are whether the 2 suits are the same if the same evidence would sustain both. And the second element focuses narrowly on what must be proven. And this rule focuses this rule focuses on the evidence, whether the two cases are subject to the same evidence, whether the same evidence can prove the results of these two cases. And then the second test is the transactional test. It is more modern one. And there are three elements we're evaluating. The first one, two suits are the same if they arise from a single group of operative facts, regardless of the legal theories or remedies. And this one will look at the occurrence transaction, whether the dispute came from the same occurrence and background. If the two claims originated from the same background, we consider that they are the same cause of action. And the second element is it is adopted in Restatement Second of Judgment, Section 24. And then the third element is focuses on the factual nucleus, not the evidence or legal labels. The reasoning behind this case. The first and third elements were clearly met. We just mentioned the first one, whether it is finality. Yes, this is finality. And whether they are from the same plaintiff and defendant. Yes, the same plaintiff and defendants are in both cases. The key dispute is the same cause of action. The Illinois Supreme Court needed to decide whether to apply the same evidence test or the transactional test. The court chose the transactional approach as more modern and pragmatic, consistent with the Restatement Second and the federal precedents. And people might ask why the transactional test is better. There are several reasons. The same evidence test is too narrow. It's very easy to create new cases, claim splitting, and to waste the time and resource from the judicial system. And the purpose to apply transactional test is, first of all, to promote judicial economy and to prevent harassment, and the last one, encourage finality and efficient resolution of disputes. How to apply this test in the instant case? The first one, the two cases were originated from the same court of operative facts, because all the facts are the same. It's about the cities handling the evaluation and approval of the plan, and the city delays the plan and cause the consequence. And the second reason is if you just change the theories and did not change the underlying transaction, because all the two causes of action actually were from the same transaction, the same background. And therefore, the rival parts' later claims were barred because they could have been raised in the first federal court. The rationale behind these rules is the first one, the claim preclusion prevents a plaintiff from repackaging the same disputes under different legal theories and in multiple courts. The second one, the transactional view aligns with the Restatement Second of Judgments and federal approach. And then the third one, the court should resolve all claims arising from a single set of facts in one proceeding to preserve judicial efficiency and consistency. And then the last one is the continued application of the same evidence test is inconsistent with the pragmatic goals of modern res judicata law. The holding and disposition. Real parts breach of implied contract and abuse of governmental power claims arose from the same transaction as its earlier 1983 claim. Therefore, they were barred by res judicata. The appellate court's reversal was reversed, and the trial court's dismissal was affirmed. The key takeaway from this case, and also these charts can help you to prepare for the cold call. And most likely the professor will focus on these points. The first one, res judicata elements. First of all, finality and the same parties and the same cause of action. The same evidence test focus on the evidence, whether the two causes of action share the same evidence. If the evidence are the same, if the evidence, the used evidence is the same and they are under the claim preclusion, but if they use different evidence and they are not. But this one is the outdated approach. The most modern approach we are applying here is the transactional test. It is evaluating whether the two causes of action came from the same background, same transaction, same occurrence, same facts pattern. And claim splitting disfavored. We don't want to split too many cases, and the policy is judicial efficiency and finality. The bar exam and class insight. River Park is the Illinois Supreme Court's adoption of the transactional test, and expect exam question ask how to determine whether two claims are the same cause of action, and how res judicata differs from collateral estoppel, issue preclusion. Mnemonic for res judicata elements: FPC, final judicial, the final judgment, parties identical, and cause of action identical. Here, lastly, so we're evaluating a hypo and to practice the rule we are learning today. If a plaintiff sues in federal court for constitutional violations arising from the city's permit denial and loses, can they later sue in the state court for breach of implied contract over the same denial? The answer is no, because applying the same transaction test and the two causes of actions, the two claims arose from the same occurrence and transaction. Therefore, we determine that it is barred by the claim preclusion rule. So it will be dismissed. Okay, so that will be everything for today about this case. If you like this way to prepare for your cold call, please join my next discussion in my next episode. Have a nice day.